My name is Emma Patterson. I'm the Principal Solicitor at Patterson Law. This is a short talk about making a special reasons argument. Special reasons arguments can be used to help avoid penalty points or disqualification. A lot of people think that you can only make a special reasons argument to avoid disqualification from driving under the court's obligatory or mandatory powers. So, for example, in relation to drink driving or dangerous driving. But you can make special reasons arguments to avoid penalty points as well. And the provisions are contained in section 34 of the Road Traffic Offenders Act 1988. And basically that section says that, here we go, I've got it here, where a person is convicted of an offence involving obligatory disqualification, the court must order him to be disqualified for such period not less than 12 months as the court thinks fit, unless the court, for special reasons, thinks fit to order him to be disqualified for a shorter period or not to order him to be disqualified. Now, the legislation is complicated, and that seems to suggest that it's only relevant in relation to obligatory disqualification cases, but special reasons arguments can be used in relation to any endorsable offence. And the most common area where we will make a special reasons argument when it's not a case where there's an obligatory ban, a mandatory ban involved, are things like speeding cases where there's a medical emergency. For example, we had a father whose child had badly injured his arm, and he went through a speed camera at about 43 miles an hour in a 30-mile-an-hour limit on his way to casualty, and we made a special reasons argument to avoid endorsement in that case, which was successful. You might have heard of the case of Alex Ferguson, where he had some sort of stomach upset and said that he was dashing to the services to be able to use the toilets, and in that case it would have been a special reasons argument to avoid either endorsement or disqualification, and we've made similar arguments in similar cases which have been successful. Another area of simple endorsable offences rather than mandatory ban offences where we use special reasons arguments a lot are no insurance cases. And there's an old case from I think it's the 1940s, but it's as good now as it ever was. It's called Renison and Nola, and I talk about it a lot more on the video on no insurance offences. But in essence, it says that if you can show that you had an honest and reasonable misapprehension that you were insured, then the court has a discretion not to give you the points, and that can be particularly important when somebody's got points already, and the no insurance offence carries 6 points, so it could end up putting them at risk of a totting ban, or new drivers who are in their probationary period and make a mistake with the insurance can end up being revoked. So we're always happy to talk to you about special reasons arguments in those types of cases. There's no set definition of what can or can't be a special reasons argument. This is the only criteria. It's a case called Wickings, and in the Wickings case, the higher court said that it must be a mitigating or an extenuating circumstance, so it must be something that the court makes the court empathise or perhaps feel slightly more sorry for you than they normally would. It must be something that makes the offence less serious than it would normally would in sort of basic circumstances. It can't amount in law to a defence. So if you have a defence, then you won't be making a special reasons argument. It's not about defending the allegation. On a special reasons argument, the plea would be guilty, and then the special reasons argument is part of the sentencing exercise. So it's part of the exercise that magistrates go through when determining how to punish you, but it mustn't be a defence. It has to be something just that's mitigating. This is probably the most important criteria, this criteria number 3. It must be directly connected to the commission of the offence. So the way I normally explain that is that it must tell us why the offence occurred. It must explain why the offence happened. It can't be something that's relevant to you. So a special reasons argument wouldn't be, don't give me the points because of the impact it'll have on my job, or don't give me the points because of the impact it'll have on my ability to drive. It's about the offence itself. It must explain to the court why the offence occurred, rather than being something that's specific to you as an individual. So that's probably the most important factor. We had a case once which was a failing to name allegation, and our client had a genuine phobia and some serious issues in relation to mental health and depression where he couldn't open his post. And in that particular case, the magistrates, we produced medical evidence of that phobia, and that explained why he hadn't dealt with a request for driver information. And the magistrates did agree that there were special reasons, because whilst the phobia was particular to him, it explained why the offence had happened, because he wasn't opening his post, and therefore he didn't get the request, and therefore he didn't open the mail. So that enabled the magistrates to agree not to give him the points. And then the final one, which is really sort of a rehash of the earlier ones, it must be something that the court ought to take into consideration when deciding what punishment to impose. Now, don't take special reasons arguments lightly, because whilst they are part of the sentencing exercise, and it's not the same as pleading not guilty and having a full-blown trial, you still need to go to court. So we often have people who say, I want to raise a special reasons argument, and I've sent a letter into the court explaining the circumstances. The magistrates have to hear evidence on oath to find special reasons, and also the Crown Prosecution Service have to have the opportunity to cross-examine you if they want to. So it's not the type of hearing where you can just put it in your mitigation. We often have people who mitigate on no insurance cases who would have had a special reasons argument, but because they haven't turned up at court and they haven't made it clear that they're making a special reasons argument, the magistrates have simply treated it as mitigation. And if they treat it as mitigation, you're going to get the 6 points. You might reduce your fines a little bit or your court costs, but in order to try and avoid penalty points or disqualification in, for example, drink driving cases, you have to be there, you have to stand up, and you have to give evidence on oath. In drink driving cases, there's no set list of what can and can't be a special reasons argument, but the most common types of cases where people argue special reasons are things like laced drinks, shortness of distance arguments, or again emergency arguments, and that might be a medical emergency, or we've raised special reasons when in a few different cases where people have been under threat of assault and they've been simply fleeing the scene of that incident and using their vehicle to get away. But obviously you can only go as far as necessary to extricate yourself from that situation. You can't keep driving all the way home, but in a few different cases it has worked in the past. So if you think that you may have a special reasons argument where we might be able to persuade the magistrates not to endorse your licence or not to disqualify you, then give us a call on 01626 359 800 and we'll happily do a free advice call with you, assess your prospects of success, and we'll be very honest in relation to whether or not we think you've got a reasonable chance. So give us a call and we will happily have that chat with you. Thank you.